All right, good afternoon, everyone. Today's July 7th, 2025, at approximately, we're a little late, we're on 1:35 p.m. As the newly appointed chairman, I'd like to officially call this meeting of the Louisiana Public Defender Oversight Board to order. At this time, before we begin, I'd like to acknowledge and introduce our newly appointed board members who are with us for the first time since our last full board meeting that took place on June 16th of 2025. First, it looks like we have Judge Mary Devereaux. She's been appointed by the Louisiana Supreme Court. We have Mr. Kevin Landreneau, who's been appointed by Senate President Cameron Henry. And we also have Mr. Medlock Harbison, who has been appointed by the Speaker of the House, Philip DeVilliers. On behalf of the board, we'd like to welcome each of you to the board. So that brings us to, let me get my agenda. I guess just for roll, if we could just go through to make sure that we do have a quorum. We do have present before us Honorable Judge Thaxton. We have Judge Devereaux. We have Judge Cady. We have Ms. Booty, myself, Jeff Huft, Judge DeMai, Mr. Harbison, Mr. Dwyer, and Mr. Landreneau, all present. So I do believe we do have a quorum for today. That brings us to agenda item number 2. At this time, I'd like to take up agenda item number 2, which is the adoption of the agenda. Is there a motion to adopt the agenda for this meeting? That was Mr. Dwyer. Do I have a second to adopt the agenda for the meeting? That was Mr. Harbison. So with that, all in favor or any opposed? Hearing no opposition, the motion passes. Without opposition, the agenda has been adopted. That brings us to agenda item number 3, public comments. I have received a list of public comments. I know at the last meeting we gave, I think it was 3 minutes. Personally, I thought that was a little quick. I would like to give 5 minutes per public comment. Not that you need to use all of your 5 minutes, but being that there are new board members on here, I think it's important that these new board members hear what you have to say. So, as I call your name, if you could approach the witness stand, I'll put your hot mic on. I will keep the timer at 5 minutes. Ask that you not go over, and we'll start with Ms. Tricia Ward, if Ms. Ward wants to get set up while I get the timer set up. No rush, Ms. Ward. You tell me whatever you're set up and we can begin. You ready? All right. Please begin. Hold on one second. Let me fix that. Are you?
Hello? Yes.
There we go. All right, Ms. Ward, go ahead.
Good afternoon. My name is Tricia Ward. I've been a public defender since graduating from LSU Law School in 2008, and I have served as a district defender in Evangeline Parish, the 13th Judicial District, since 2021. I'm going to walk you through the relevant statutory framework and how the legislative actions from May of 2025 inform this board's current decision. LARS 146B1 makes it clear that the board has the duty to provide supervision and oversight to the Office of the State Public Defender. That is the foundation of your authority. While the State Public Defender has the authority to contract, that authority is not unlimited. It is subject to the constraints imposed by the statute. Mr. Storn cites 15152B5 for the general power to negotiate legal services contracts. But 152B5 does not govern district defender contracts. Instead, district defender contracts are governed by 15161, and it says the office shall contract to provide for the delivery and management of public defender services in each judicial district. That That distinction matters because 15161H1 makes clear that the legislature valued continuity in the management of district offices when it stated, right here, in an effort to maintain continuity of public defender services in each judicial, there should be a district there. Any person serving as the district public defender of a judicial district shall continue to contract with the office and serve as the district public defender of that district. In short, the legislature emphasized continuity and stability in the management of district offices. The next relevant provision is 15162, and that provision defines when a vacancy in the position of a district defender occurs. And there are only 5 instances in which a vacancy in the position of a district defender occurs. Those include demotion, termination, retirement, resignation, or death. Nowhere in that statute is the word non-renewal. Nowhere in the entire statute, not just that provision, is the word non-renewal, and that is significant. We all know that when a statute is clear, we look to the legislative intent. When a statute is silent, we look to the legislative intent, and that intent was made explicit during the 2025 legislative session. And it's also why we're here today. This past spring, Mr. Storns proposed 2 bills, one including one that attempted to insert the word non-renewal into the statute. He attempted to insert language that it would have explicitly barred appeals for non-renewals of contracts because he knows what he's attempting to do right now, and right here is not allowed under the statute. There are several of you who are new, but this mirrors a pattern of Mr. Storns's. Mr. Storns, the law currently provides, and it mandates that this board develop a compensation plan and that the state public defender shall implement that compensation plan. And yet you're going to hear from my colleagues later that Mr. Storns has drawn up new contracts this year that forces the folks who sign those contracts, my former colleagues, to enter into a contract that waives this board's compensation plan, one that he is mandated to enforce. We also know that this board reviews non-renewals of contracts because Mr. Storns said it himself when he testified about the bill that became law last year. So this was the provision where he's trying to implement non-renewed. But last year, when this very board was created, Mr. Storns said, and I quote, "There are other roles for the Public Defender Board in Senate Bill 8, particularly in regards to when contracts are not renewed," or whatever. So Mr. Storns understood that what you all have been asked to do, to review when a contract has been not renewed, he understood then that this was in fact in the law, and that's why he tried to change it this past May. The reaction of the legislators when Mr. Storns attempted to pass those 2 bills just last month said it all, and I want to look at what those reactions were.
Mr. Chairman, I'll yield some of my time to Ms. Ward with the chair's permission.
And your name is sir?
John Hogue, I'm next to him.
Hogue?
Yes, sir.
How much time would you like to yield to Ms. Ward?
As much as she needs.
So just this May, when Mr. Storns tried to introduce language to change the law that you all are considering, Representative Bacala, quote, "What we did last year is we said, yes, we're going to allow these contracts to not renew when it's for good cause, and the appeal would be to a board that would be able to review, and I think we have some cases under review right now." What Representative Bacala was talking about is this exact process. And everyone in that room understood that Mr. Storns was attempting to undo and change the law as this very process was occurring. Representative Knox, Storns gave his word last year that all the allegations that you guys are making here today would never come to light. And yet you sit here today and it's exactly almost verbatim of how y'all forewarned this committee. Representative LaFleur, I was making the same sort of observation that Representative Knox was making, and that is Mr. Storns is not in the room to defend this power grab because it's nothing more than that. This board's oversight role is clear. The statutes are clear, and the legislative intent is crystal clear. What is being attempted here is outside the scope of Mr. Storns' lawful authority, and it's also in line with the pattern of Mr. Storns. I urge this board to hold firm in its duty to supervise and not simply ratify the actions that run contrary to the law and the legislative will, and find that Mr. Storns failed to assert just cause for the non-renewals of our contracts, and thus he shall continue to contract with me and my colleagues. Thank you, and I will answer any questions at this time.
Seeing no questions, thank you, Ms. Ward. Next up for public comment. There we go. Seeing no questions, thank you, Ms. Ward. Next up for public comment, we have Mr. Hoag. Mr. Hoag, Ms. Ward has used 2 minutes of your time. You'll have 3 minutes.
Thank you.
You tell me when you're ready.
Thank you. Can you hear me?
Yes.
Good afternoon, members of the chair, Mr. Chairman, and members of the committee. My name is John Hoag. I'm a proud graduate of Loyola Law School. I'm here today with my wife of 35 years, Luba, and together we have 4 children, one of whom just got married this weekend, so it's great to be with you. It's been a privilege to serve as a public defender for over 27 years. For nearly 24 years, I worked as a line defender in the 22nd Judicial District, St. Tammany and Washington Parish, where I handled juvenile, sink, misdemeanor, and felony cases. At present, I've served over 3.5 years as district defender in the 6th Judicial District. That's a rural district in northeast Louisiana that includes East Carroll, Madison, and Tensas Parish, my childhood home. I represent a rural district with real systemic challenges: substance abuse, mental health, poverty, exacerbated by a lack of basic resources such as transportation, treatment centers, and jobs. But progress is being made. I was one of the first district defenders to secure opiate settlement funds, money that we now use to support our drug court attorney. More recently, I met with the state legislator and visited the construction site for Meta's new $10 billion investment in North Louisiana. That's in the adjacent parish to my district, a monumental project for North Louisiana. I've already met Meta's representative, Henry Thornton, who you may recall was introduced by Governor Landry in this session. I see a real opportunity for a possible collaboration with Meta that could benefit and transform my district, one of the poorest places in America. That's why continuity of leadership is critical. Louisiana law recognizes this need. RS 15161H1 provides, in an effort to maintain continuity of public defense services in each judicial district, any person serving as the district public defender of a judicial district shall continue to contract with the office and serve as the district public defender of that district. This law ensures that public defense leadership remains stable, allowing us to build long-term relationships with judges, sheriffs, police juries, district attorneys, legislators, and private entities such as Meta. Being a public defender is like a marriage. It takes years of commitment, trust, and hard work to succeed. Remy Starnes does not have the discretion to ignore the law. He must continue to contract unless there is a vacancy due to demotion, resignation, termination, retirement, or death, as outlined in RS 15162. Our district defender contracts must be continued year after year under RS 15161H unless terminated for just cause pursuant to RS 15170. No just cause has been alleged by Mr. Starn, and none exist. Finally, RS 15146B1 states that the Louisiana Public Defender Board Oversight is created and established to provide supervision and oversight to the Office of State Public Defender. All right, thank you. Give me 15 seconds. Thank you. I'll only need 15 seconds. Finally, RS 15146B1 states that the Louisiana Public Defender Oversight Board is created and established to provide supervision and oversight to the Office of State Public Defender. That's your role, to exercise independent oversight and to provide that to the public defender, to state public defender. As a board, I urge you to do just that. Exercise your mandate to provide supervision and oversight to the Office of State Public Defender and insist that Mr. Starnes follow the law. I urge you to uphold the unanimous decision of the hearing committee and ensure that we continue to contract as district defenders. Thank you.
Thank you, Mr. Hoag.
Thank you, sir.
We next up have Mr. Brett Brunson. Mr. Brunson, you have 4.5 minutes.
Thank you. I'm Brett Brunson. I'm the Chief Public Defender in the 10th Judicial District for the last 18 years. That's Natchitoches Parish. I graduated from LSU Law School in 1978, and I've practiced law for 46 years, mostly as a trial attorney. I started as a public defender in Sabine and DeSoto parishes, and moved to Natchitoches Parish later on. Then I gave up a successful commercial litigation practice and 2 bank clients to become the district defender in Natchitoches in 2007. I was the first district defender hired by the Louisiana Public Defender Board after the reform in 2007. I worked under 5 different state public defenders. In 2015, I was president of the Louisiana Association of Criminal Defense Lawyers. So I have not just been a local leader, I've been active throughout the state as a statewide leader. We've never had a serious problem in the 10th in the time that I've been the chief. There's no problem there now at the moment. Remy Starnes is refusing to follow the law, and he has you here today as a result. He is openly ignoring the compensation plan approved by 2 prior boards, including this board. He's forcing district defenders to sign contracts that contain unlawful terms. He's circumventing board approval of funding of capital defense by running it through the districts, which are prohibited by law from spending funds outside each district. He is defunding the Louisiana Appellate Project, which is a successful resource for all district appeals, and there is no successor in place. He says he will keep trying to get rid of any board oversight and keep trying to get rid of the board. He admitted that, said it right here at the board meeting on June 16th. He is trying to get you to abdicate your authority to oversee and supervise him. He's trying to get you to ignore the law too. The only issue before you today is, does the evidence regarding the legislative intent and the enactment of sections 161 and 170 give you a reason to ratify the committee's reversal of its earlier recommendation and resolve that Mr. Starnes be required to continue our contracts? The legislative history is being described for you by my colleagues, but in short, Starnes tried to amend the law a few months ago to get rid of these protections. Representative Bacala recently said that his amendment last year protected us. Representative Knox said that Starnes is now trying to do exactly what he told the Administration of Criminal Justice Committee last year that he would not do. Remy Starnes admitted that this was subject to the requirement of showing of good cause, and it also must be done in good faith. Both of those are absent under the circumstances of me and my 4 colleagues. That makes the decision, his decision, reviewable by this committee. The law is in our favor. Starnes did not allege any cause for the letters he sent to us. They contained one sentence saying that he was not renewing our contract and giving no reason, because no reason exists for any of them. Lacking good cause for his actions, the action should be overturned. Disparate treatment of women and minorities should not stand in this state. The law requires our contracts to continue. Thank you for your interest.
Thank you, sir. That brings up next Ms. Deidre Fuller.
Testing. Thank you. Good afternoon. May I have your attention, please? My name is Deirdre Fuller. I was the Chief District Defender in the 9th JDC. I was the first African-American female in Louisiana as chief and the first woman to hold the position in Rapides Parish. I have established relationships with national organizations such as the National Association of Public Defenders and the National Association of Criminal Defense Lawyers. I've been a board member of LAP, the Louisiana Appellate Project, for almost 8 years. I'm committed to public defense. After 9 years as a district defender, the state public defender has decided not to continue my contract, though the law provides that he's required to do so. Specifically, revised statute 15161H1 states, in an effort to maintain continuity of public district defender services in each judicial district, any person serving as the district public defender of a judicial district shall continue to contract with the office and service as the district public defender of that district. Simply, if you are the district defender today, you will be the district defender tomorrow. The law does not say may continue. It says shall continue. No one must be allowed to sidestep the law, including the state public defender. Because the state public defender knows exactly what the law provides, he went back to the legislature last month to try to change it, to get rid of this board in the middle of this review process. Though he labeled it a cleanup job, it was in essence an attempt to clean out this oversight board. But the ACJ committee read the tea leaves, and the bill sponsors voluntarily retreated and apologized for bringing those bills. The law goes further. As previously stated in revised statute 15162, it provides that district vacancies only occur due to demotion, resignation, termination, retirement, or death. So why are we here? Why are we really here? We exercised our right to oppose Senate Bill 8 and testified against it before the House Administration of Criminal Justice Committee in February 2024. The bill's main purpose was to eliminate the prior board and to concentrate as much power as possible in the hands of the state public defender, and that's exactly what it did. But because my colleagues and I testified to challenge the wisdom of that decision, the legislature opted to create this oversight board on which you currently sit. Our contracts would not continue because we oppose the state public defender's maltreatment of certain female colleagues, and we pointed that out to prior board members. These are our crimes. For that, our contracts have been arrested. Per the code of the state public defender, our penalty is to not be continued. If we are convicted, we will lose our careers. Personally, if I am convicted, I will be denied the benefit that some of my counterparts who have had contracts for decades, they've been chiefs for 20+ years. What they enjoy is retirement. I will be denied the benefit of 1 year that I need to vest in my parochial employees' retirement system in my office. I will be denied that benefit to participate in the DROP program for the required 36 months to enhance my retirement fund. I will be denied the right to a retirement to support myself after my work life ends. I worked for it, I earned it, it is mine. We do not seek more than the law provides, a statutory right to continue our contracts when there is no just cause or good faith to end them, much to the state public defender's chagrin. You have the oversight authority and the obligation to follow the law. I'll answer any questions. Thank you.
Seeing no questions, thank you, Ms. Fuller. That brings us to Ms. Michelle Andrepont.
Yes. Ready. Good afternoon. My name is Michelle Andrepont. I was admitted to the Louisiana Bar in October of '92, and I joined the Caddo Parish District Public Defender Office in October of 1994. I was appointed the District Public Defender there on February 20th of 2020, where I remained until last Monday. I've spent over 30 years defending the constitutional right to counsel and fair representation. Today, I speak out because Mr. Starnes is attempting, or has at this point, removed myself and my colleagues who collectively have nearly 115 years of public defense experience. We have dedicated our careers to public defense. We're not surprised that this has happened. We warned the legislature that it would when Mr. Starnes sought to have control shifted from the board to him. In response to those warnings, the legislature acted in 2024, giving this board and a committee of this board the authority to review such actions. As you've heard, based on 146B1, you have the supervision and oversight of the Office of the Public Defender. 161H1 provides for continuity in public defender and specifically district defender services. 162 provides that vacancies do not occur by non-renewals. And 170 provides our right to this process that we're in now. During SB 8 hearings last year, Mr. Starnes acknowledged the board's role in reviewing non-renewals. He said, I guess we didn't put that one on the board, and I apologize. Here we go. There are other roles for the Public Defender Board in Senate Bill 8, particularly in regard to when contracts are not renewed or whatever. Mr. Starnes knew then, last year, in 2024, that we had a right to review and that the board had a right to review non-renewals. Representatives Bacala and Villio made that clear again this year. The intent of Bacala's amendment was job continuity, not temporary employment. Representative Bacala said, if you got the job today, you got it tomorrow. Mr. Starnes now claims that these protections were just for fiscal year 25. That's not true. His interpretation relies on a note that's in the statute. An amendment offered in Jude B on the Senate side very early on when SB 8 was being considered. That was offered by Senator Cousin. He let us extend our existing contracts at that time for 1 year to allow this board, the new Oversight Board, time to establish the compensation plan for district defenders. That language is not in the statutory language of 161H. It's in a note. That was proposed and adopted on February 20th of 2024. Bacala's amendment to 161H that allows for the continuity was proposed and adopted on February 29th, well after the amendment from Cousin. Representative Villio and Bacala made it clear that he was offering his amendment because he didn't believe the previous amendment went far enough. Mr. Starnes stated in his brief to you that Bacala's amendment failed, and that is also false. That amendment passed and was made a part of the law. You can look it up. Legislative history shows that the final amendment from Bacala was meant to go further. It gave us more protection, not less protection than what Kuzan had proposed. There's no question what the legislature intended. As Ms. Ward told you, Mr. Bacala said, what we did last year is we said, yes, we're going to allow these contracts to not renew when it's for good cause. And the appeal would be to a board that would be able to review, and I think we have cases under review. Ours are those cases. The intent is very clear. And this year was Mr. Starnes' third attempt to go before the legislature and have the laws change and all the power shifted to him. What we have in common as the DD5 that we call ourselves is we testified at the legislature and we have testified at this board and at the previous board against policies proposed by Mr. Starnes that we felt were not appropriate. Yes, I've opposed every one of his efforts to seize power because I believe in independence, accountability, and justice. This isn't just about us, the DD5. It's about protecting all those who speak truth to power. It's about the 5 of us having the courage and the audacity to speak up and speak out when we disagree with a policy. As public defenders, if I may, I have about 30 seconds. As public defenders, this is not just our responsibility, it's our duty. We fight injustice all the time. We happen to be fighting for ourselves this time. This is about whether public defense will remain independent or will become even more politically controlled. I'm proud of my service as a public defender. I have lost my job, but I will not lose my voice and I will not lose my integrity. And I urge you to affirm the committee recommendation. I ask that you reinstate us to our rightful positions, retroactive to July 1 of this year with back pay. Please stand up, not just for us, but for justice and for all of the defenders who will follow us. Thank you.
Thank you, Ms. Andrepont. That brings us to, is it John or Jean? It's Jean. Miss Jean Faria. Whenever you're ready, ma'am.
Good afternoon, members of the committee. My name is Jean Faria, and for the benefit of those of you who do not know me, let me tell you a little bit about myself. I was a line defender in East Baton Rouge Parish in the 1980s. In the 1990s, I worked as the first chief executive officer of the Louisiana Indigent Defender Board under the auspices of the Supreme Court, with a board of directors, the likes of which Victor Busey, Leah Gary, Camille Gravel, among a few of the members, including Sam Dalton. Then I went on to become a federal public defender for 14 years in the Middle and Western Districts of Louisiana under Rebecca Hudsmith, and then I was recruited to become the first state public defender under the Act 307 of 2007, a precursor of this board. Along the way, I served as a member of the board of directors of the National Legal Aid and Defenders Association for 10 years. I chaired that board for 2 years. I was a member of the American Bar Association's Standing Committee on Legal Aid and Indigent Defendants for 2 terms. I'm a founding member of the National Association of Public Defense. I am also a former chair of the Criminal Justice Committee of the State Bar Association and a former chair of the Criminal Justice Committee. And in that capacity, I offer the following comments. At the time that Act 307 was implemented, there were no contracts, and with the abolition of the local judge-appointed indigent defender boards, all chief defenders, now called district defenders, were grandfathered in. The district defenders maintained their positions for years without contracts. After a few years, it became clear that many of the district defenders were not following their statutorily mandated duties, and to be fair, this level of oversight was entirely new to the district defenders. To address the problem, the board authorized my general counsel to develop a contract which outlined the statutory duties of the district defenders. There was no evergreen provision outlined in the contract because there was a priority placed on continuity of leadership in the field. The intent was to clearly articulate the district defender's duties and to annually remind them of those duties. In my tenure as a state public defender and in my employment with the state board from 2008 to 2020, there was never an involuntary non-renewal of a defender's contract without cause. The role of this board is to oversee the work of the state public defender, and the board's role is essential to determine whether the state public defender is performing statutorily mandated duties appropriately in the best interests of the clients and according to best practices. To date, the current state public defender has terminated 6 of 11 women over the last 3 years. 4 of them are black women. Only 2 men, also who have had no performance issues, have been denied a contract for no cause, and they simply supported these 3 women before you today. And in order to properly supervise the state public defender and to demonstrate the district defenders what to do and what not to do, a for-cause hearing is essential for the system. In the very few states where the governor appoints the state public defender, the public defenders are state employees and are afforded the protections of the civil service which require for-cause hearings. The states of Iowa, Rhode Island, Vermont, Alaska, Delaware, New York, Wyoming, Montana, and Idaho are the only other states that have governor-appointed public defenders and state public defenders. And in those states, it is essential for you to understand that there's a profound difference. They are civil servants with all of the protections of civil service. They cannot be terminated or fired or non-renewed or whatever you want to call this rose by any other name without just cause. It is essential to any system that people understand what is appropriate behavior and what is not appropriate behavior, and exercising your First Amendment right to disagree, which in a healthy system is appropriate and is honored as it makes us better decision makers, and it certainly did in my years as the first state public defender. I applauded the difference of opinion. I put my reputation on the line for these 5 defenders. I know them personally, I know them professionally, and I would never be here before you telling you that these people have been wrongfully terminated as a result of their exercising their right to speak freely. Thank you. I'm happy to answer any questions that any member may have.
Seeing no questions, thank you, Ms. Ferrier.
Thank you.
Thank you, ma'am. That brings us to Ms. Pamela Metzger.
Thank you.
Whenever you're ready, ma'am, take your time.
Thank you. Good morning. I'm Pam Metzger. I'm a professor at the SMU Dedman School of Law, where I run the Decent Criminal Justice Reform Center. Before I went to SMU, I was a professor at Tulane Law School for 17 years. I'm the lawyer who was appointed to represent all of the Orleans Parish inmates after Katrina. I worked on Act 307, the predecessor to the current state law on public defense, and I was a member of the Louisiana Public Defender Board, appointed by the governor for many, many years, including years when Ms. Ferrier was the chief defender. I'm also a national expert on the role of independence in the delivery of the constitutional right to counsel, and that's what I'm here to talk about today. It's essential for a criminal legal system to work that public defenders have structural independence to do their jobs on the ground effectively. Let's face it, no person, not even a governor, perhaps especially a governor, can be both a prosecutor and a public defender at one time, nor should they be asked to. But in the current system, what prevents the governor, who appoints the state public defender every 2 years, from having direct control over the work of every public defender in the state is this board, is this board's oversight, this board's ability to do what the legislature charged it with doing into 2024 and renewed its charge to this board again in 2025, which is to stand for independence in the exercise of public defense, which means giving public defenders independence to speak for their clients in the way that benefits their clients without fear of reprisal, politically or personally, to advocate for the budgets they need, to pursue the reforms they need, even to make decisions about how cases are allocated within this office. And again,
88% of the people in your state rely on public defenders to be their advocates. They rely on public defenders to stand between them and the awesome powers of government, the noise of the media, and the risk of a hasty conviction. Independence is the first among the American Bar Association's principles, among its 10 principles of a public defender independent system, and for good reason. Not simply because the Constitution requires it, but also it's good governance. When there's not independence, what we have seen over and over again is litigation in Montgomery County, Louisiana, Pennsylvania, Luzerne County, Pennsylvania, settlements of more than $250,000 each over wrongful terminations that interfered with independence. In Oregon, where a state public defender board was involved in terminations that violated independence, $350,000 in settlements. And even after direct lawsuits ended, you can imagine the unbelievable flow of post-conviction litigation from people who have been convicted and left to wonder, was my public defender representing me, or were they curbing their advocacy so as not to incur the wrath of the governor, who might instruct the state public defender, get rid of that lawyer. There are too many acquittals. And lest we doubt it, let's note that the Attorney General has offered advisory opinions in these matters, but the Attorney General is currently litigating cases against public defenders all across the state. The appearance of impropriety, I'm not suggesting any actual impropriety, the appearance of impropriety alone undermines what we come to view as a fundamental American value. If we think about it in this light, look, there are lots of boards in this state, but you're not the board overseeing an art museum. You are literally overseeing the most American of values. The right to counsel, the right to have someone stand between you and government tyranny. And absent this board upholding the committee's decision, what you have is an utter lack of independence, the collapse of even a pretense that there is a barrier between the governor, the state police, the state attorney general, and the men and women who every single day are defending our Constitution in the courts of Louisiana. It remains true that a loss of public defense independence is a loss not only of a belief in the way our system works, but in the proper functioning of our system. It is the criminal legal system in part that has made this country the envy of the world. And it is the independence of public defenders that guarantee that. This board was created to protect that. And this board's obligations to independence means that it's obligated to guard against political interference in all of its forms and to safeguard independence. Thank you. I assume there are no questions, since that's been the trend.
Thank you, ma'am. Seeing no questions, thank you. That brings us to Mr. Rick Schroeder. Mr. Schroeder, take your time, and we'll begin whenever you're ready.
I appreciate that.
No problem.
Since I represent 5 different defendants, I assume I get 5 minutes each, 25 total. I won't need that, I'm just joking. I'll put this up there. I'm ready, sir. Okay, great. Why are we here? We have 5 district defenders with over 100 years of service. Not one of them has had a disciplinary problem, despite all the standards set out in the law, the legislative audits that are available, and in fact, we're actually occasioned to one of only to female district defenders in the state. They pass with flying colors. Why are these districts being denied? Why is the state system being denied that? Mr. Starnes is not here. He doesn't attend most of these hearings. Why are we here? The law is absolutely clear. 161H1 says there's a duty to continue to defend. 162 states what the vacancies are, and there's no such thing as non-renewal. 147C1, which defines the rights of the Office of the Public Defender to contract, and this is an important one. You know, it states the office, Mr. Starnes, is prohibited from using its power to contract to change the structure of a local program, delivery method, or to terminate personnel without cause. The law does not allow what he's doing, but that's not unusual with Mr. Starnes. The committee members who have been here a long time will tell you, and you will learn from facts, that he has, in my opinion, complete contempt for this board. In the legislative arena, he's tried to do away with it. And failing that, he's done away with it himself, he believes. He writes contracts which are illegal. His contracts don't reference the termination provisions of the law. His contracts say, I can get rid of you in 30 days for no cause. That's what his contracts say. His contracts say, I don't have to follow the compensation plan, and you'll waive the board's compensation plan, or I don't sign the contract. That's what they say. His contracts say to be a district public defender, you have to waive your right to an appeal if I terminate you without cause. That's what his contracts say. That is absolutely illegal. You cannot contract away the law. 6 meetings of committees in this board, 2 adjourned with no quorum, all because the law is not the problem. The problem's the lawyer. He's why we're all here. He's getting rid of most of the women that he's got something on his website now that says, I've hired more women than anybody else. Maybe so. But anybody who speaks out, who comes to the legislature, who appears before this board, he's got the message out, I'm getting rid of you. The parade of horribles that will happen if you don't adopt the well-reasoned opinion of the committee is total control over public defenders. I can tell you, who would want a job as a district public defender when you can be removed at any time without cause and without a hearing, losing everything that you've built up? And no one has to tell you why, and you won't know why. None of us will ever know why, just whether it's discrimination, gender, race, or any other reason. We'll never know. No good lawyers will take the jobs, and we'll lose over 100 years of experience. 170G is the remedy. 170G is the sword given to you. It's the protection given to you. And 170G says when you find someone was terminated without cause, you will order the immediate reemployment or reinstatement of that defender. And you must make it retroactive. You're allowed to make it retroactive. So I ask you, tell Mr. Starnes, show up to meetings, tell him to follow the law in the contract so that you're not here again and again as everybody begins to litigate contracts which have illegal provisions in him. Avoid the litigation that results when people's constitutional rights to appear before a legislator are trampled upon and their occupations destroyed. Avoid those harms to this board's activities, to the important provision of public defense on the ground. This is the reason this board exists. And I'll answer any questions.
Thank you, Mr. Schroeder. Seeing no questions, thank you for your time. That brings us next to, we have Mr. Tom Jones, who is the Director of the Civil Division at the AG's office. Mr. Jones, take your time, and whenever you're ready to begin, I'll start your time.
I do move slow. Mr. Chairman and board members, I was asked to come here and talk about an opinion that the Attorney General's office issued and to answer any questions you may have. I'm not defending anybody. I'm not complaining about anybody. Nobody admires public defenders more than I do. They do heroic work. They're the backbone of the criminal justice system, and I'll tell anybody that anytime. But on this opinion, we were asked to review a pretty narrow question, and that is, when a contract expires by its one-year term, is the Public Defender Board obligated to continue that contract in effect? The answer seemed pretty obvious to us. If the contract expires, it no longer exists. Somebody's not being removed, nobody's being terminated, nobody's being fired. The contract just ran out, it expired. And if it's not renewed, the statute doesn't require it to be renewed. If you're terminated, yeah, you get a hearing, somebody has to show that you did wrong in your job. Same thing, termination, removal, any of those terms. But nowhere in those statutes does it say that anybody is entitled to a hearing when the contract expires. That's not an occasion for anybody to examine whether or not that contract should or shouldn't be renewed. That's left to the discretion of the board president or whoever is in charge. So that's all our opinion said. If a contract expires, it ran out and it's over. And is somebody obligated to renew it? No, because the statute doesn't say that. The provision that's been cited that the contract, that people in the office shall continue to contract simply means that people in the office continue to contract just as they have in the past. But that doesn't mean the contract lasts forever. Who in the world would think that a contract lasts forever? But that seems to be the argument I've heard today. It's got to be renewed. Nobody has any discretion. You can't do anything as far as ending the contract, even though it ends itself. And so that's kind of what we saw when we wrote the opinion, looked at the statute, and tried to figure out what the law said. There's no such thing as expiration for cause. A contract expires, not for cause, not without cause, just because the term of the contract ran out. And we just saw it pretty much that simple. Obviously, we may be wrong. Somebody may think differently, but that's how we wrote our opinion. It wasn't just one of us that wrote the opinion. We get together and we talk about the opinions and discuss them. People read the statute, people read cases, and that's what we did to arrive at our opinion. We think the opinion is right. We stand by it, and that's pretty much what I came over to tell you about today. If y'all have any questions about it or want to ask anything, I'll try to answer.
I have a question.
We have a question from Judge Thaxton.
Yes. Hey.
I read this opinion when it came out. I read it again today. Did you consider the provisions of paragraph H that you've referred to that says, for continuity, any person serving as a district defender shall continue to contract with the office? It's not in here. Did you or whoever wrote this, Ms. St. Amant, consider that?
Yeah, we looked at it. We went through the whole statute.
Okay.
And talked it through. That was one of the things we looked at. The way we understand that is that people are supposed to continue to contract. Now, it doesn't dictate the terms of the contract. It doesn't say the contract has to last forever. It just says you're supposed to keep contracting with the board so that you get continuity of service if possible.
Yes, sir.
Now, And again, I'm not here to defend Mr. Starnes.
I understand
I don't
that.
know what decisions he made. I've heard today, but
I understand, and I'm not trying to be confrontational. I just want to make sure we're on the same page. There is a provision in the statute that provides grounds for termination, demotion, et cetera. It's a long list of things. Do you believe that that applies to the district defenders even though they have a contract? They could still be terminated for cause under their contract?
yeah, the statute says so.
Okay, so they wouldn't have a perpetual employment contract by this continuing to be renewed. They could always be terminated for cause, and then that would trigger the hearing part of the statute.
Yeah, except that if you read H the way it's being read today, it would be perpetual because it's being construed as a compulsory renewal rather than a discretionary renewal, and that would make it perpetual.
Well, I guess the two sections would be, number one, you shall contract. That's number one. Number two, regardless of your obligation to contract for continuity, you can be terminated. Those are two different issues, aren't they?
I think that
Okay, thank you so much. And again, I didn't mean to come across as offensive or confrontational if I did. Thank
he
you, Mr.
didn't a
Chair.
bit.
We have a question that's from Mr. Landrino.
Okay, here we go. In 161A, it says that the office shall contract for a period of up to 5 years with the district public defender to provide the delivery and management of public defender services in each judicial district. So is that, did you first consider that when writing the opinion?
We did. We considered it, again, discretionary. You can go up to 5 years. I've read the contract that exists, and it's for 1 year, but you could go up to 5 years the way I read that.
So contracts can be written for 1 year, for 3 years, but no more than 5 years. Is that correct? And does that in and of itself suggest that there is a time when that period will expire, that a contract will expire?
Correct.
And it sounds like, and again, I'm new to this, I'm new here, so it sounds like what our dispute is, although it's not clear, is that we're talking about contracts. Is that right?
That's the way we read it.
Okay. When a contract expires, is it considered terminated?
It's not considered terminated. It's ended.
It has ended.
Contract is over. The obligations of the two parties ends. One doesn't have an obligation to the other, and the other doesn't have an obligation to the principal.
And does that, when a contract ends, does that create a vacancy?
I don't know that it creates a vacancy if that office were not occupied by reason of that contract. The way I read vacancy, it would create a vacancy, yes.
And do you know why it would be that the legislature did not think about incorporating renewals or terms for renewals in the statutes?
I don't know why the legislature did what it did.
In any of the documents you reviewed, did you see anything where they had a discussion that related to renewals of contracts, purposes for renewals, or anything to that effect?
No, I didn't see anything about renewals or expirations in the statute.
Is it your understanding from the statutes that the office of the public defender is the party, according to these statutes, to enter into contracts with district public defenders?
That the office enters into
Yes,
contract?
the office of the public defender.
Yeah, that's what I understand.
And is that a change from the prior statute?
I don't know. I can't tell you that.
All right, thank you. No further questions.
Thank you, Mr. Landrino. Any other questions from the board for Mr. Jones? Seeing none, thank you, Mr. Jones.
Thank you.
That leaves us with Mr. Christopher Walters. Mr. Walters, when you are ready, if you could please identify yourself, and I'll begin your time.
Thank you, Mr. Chairman and members of the board. Christopher Walters, Deputy Executive Counsel for Governor Landry's office. Members, I have hesitated to come down here for numerous reasons, but I felt like it was appropriate and required in this instance when we are talking about what the legislature did, how the statute changed, and what it means for you all as a board. Now, I'd like to say right up front that I'm not going to be talking about the merits of whatever decision the state public defender made with respect to these 5 district defenders, or with respect to the other 32 where he did renew those contracts or contracted with someone else. What I will tell you is that I was there and I was a part of the passage of Senate Bill 8, and became Act 22 of the 2024 second extraordinary session. And I would just like to point out a couple of things for the members here. First and foremost, if we're going to look at the legislative history, then we go to the legislative history of Senate Bill 8. And the most relevant portion of that was in House Criminal Justice Committee. That was the hearing held on February the 27th of 2024. And if we look at Senator Mike Reese, who was the bill author for Senate Bill 8, he will explain beginning at time-stamped 8 minutes, 15 seconds in the full House video, explaining the amendments that have been made to Senate Bill 8. He says additional amendments protected the current contracts and allow the district defenders to choose to renew their current contracts for an additional year at their present terms. So again, alleviating fears that some major change would happen right away and would have a negative impact on people currently providing the service in our state, we gave them the ability to voluntarily choose to renew their existing contract for another year, i.e., he was talking in February of 2024, meaning they would be able to choose to renew for 2024-2025, which contract year ended June 30th of this year. Senator Mike Reese again explains, starting at 11 minutes and 30 seconds, and that the amendments would honor all contracts in place through this fiscal year and gives the district defenders the ability to choose to renew their contract for up to 1 additional year. Now, the question becomes, why would he stress that? What is the point of that if they're going to continue to renew automatically absent something else in any year after that? That's really the question that it comes down to, that we've been beating around the bush about. And if we go to one of the individuals who was just sitting here, District Defender Michelle Andrepont, in her testimony before House Committee on Administration of Criminal Justice at hour mark 2, minute 22, second 55, Michelle Andrepont says, "There's nothing in the bill that protects us from non-renewal of our contracts. Termination or demotion goes before the board for review. Non-renewal of our contracts does not." That's someone who just sat here and told you that was not what Senate Bill 8 did, Act 22 did, that it had no effect on non-renewal. In addition, one of our board members here, and I don't mean to call you out, but Judge Thaxton, presenting his testimony, says that new public defender, meaning the state public defender under this bill, meaning the new bill, Act 22, can hire and fire, non-renew after 1 year, unilaterally decide what to spend with $48 million. Right now, 11 of us have to agree. Now, there were many more statements throughout the legislative history, but I thought those were most luminous in terms of the intent of this particular provision and the intent of what we are talking about today. If you go through and you look at what changed under Senate Bill 8, Act 22, from the old board and the old structure to the new board and the new structure, you can pull up a PDF of Act 22 and you can simply Control F and find board and then just start going down through it. And here's what you will find. You will find that the new board, which you are all members of now, have the following relevant duties: approve contracts of $250,000 or more, establish a compensation plan for district defenders, hear appeals of corrective or disciplinary action taken by the office against a district public defender during the term of their contract, approve the strategic plan developed by the office, and review and approve recommendations from district public defenders regarding the method of delivery. The office has all of the other authorities that previously the board held. In fact, you do not contract with the district public defenders any longer as a board. The office contracts with the district public defenders. Thank you all.
Seeing no other names on the public comment, this would conclude agenda item number 3. Moving on to agenda item number 4. At this time, we'll take up agenda item number 4, which is the report and recommendation of the hearing committee. This time, the chair will now entertain any motions related to this agenda item number 4. Hold on one second. I see Mr. One second. Mr. Harbinson, Mr. Harbinson, do you have
I do.
a motion?
Yes, Chairman. Mr. Chairman, the members of this board have all had an opportunity to review the materials in the packet, including the original hearing committee report and recommendation from the April 7th, 2025 hearing, which was transmitted to the board on or about May 20th, 2025, as well as the second or revised hearing committee report and recommendations from the June 18th hearing that was transmitted to this board on or about June 20th, 2025. In addition, we have the Attorney General's opinion, number 240115, that sets forth the plain statutory provisions governing this question and concludes 3 basic principles. 1, the state public defender contracts with the district public defenders, not the board. 2, all of these contracts are 1-year contracts that follow the fiscal year. 3, the right to a hearing and investigation under LARS 15170 is limited to instances in which the district public defender is disciplined or has his contract terminated early. There is no right to a hearing or an investigation if the annual contract is simply not renewed. Finally, we have Act 22 of the 2024 Second Extraordinary Legislative Session. The legislative history and statements is previously set forth by the state public defender and is explained by Mr. Walters from the governor's office that makes it clear that the legislator's intent, as stated in Act 22 and as explained by the bill's author, Senator Mike Reese, was that each and every district public defender would get the option to renew their 1-year contracts for the fiscal year 2024-2025, which ended on June 30th, 2025, and that the state public defender would have the sole statutory authority to decide with whom to contract to be the district public defender in each district. Accordingly, I make the following motion. Okay. I move that this board adopt the original committee hearing report and recommendations from April 7th, 2025 hearing that was transmitted to this board on or about May 20th, 2025 that found that the state public defender has no obligation to enter into new contracts with any of the 5 public defenders and thereby reject the second hearing committee's report and recommendation from the June 16th, 2025 hearing that was transmitted to the board on or about June 20th, 2025.
So just to be clear, there is a motion to, we have 2 hearing committee reports in front of us.
Adopt the report from the April 7th and reject the report from June 16th.
So there's a motion on the floor to adopt the April 7th, 2025 hearing report, in which the conclusion was that the decision of Mr. Starnes was maintained, and to reject the June 18th, 2025 report. Is that?
That's correct.
Is there a second on this motion?
I second it.
It's seconded by, that's Judge Devereaux. So we have a second. So now we'll open this up for discussion, if there's any discussion that would like to be had. Any discussion? Is that Ms. Boutte trying to hit?
Yes,
Yeah.
it's me.
All right, there we go. Ms. Boutte.
I would like to
Well, first of all, welcome all the new board members. It's a pleasure to have you all here so that we can pass a vote on this matter and move on past our statutory obligations. Secondly, I would like to say that procedurally, the last time the full board convened, the motion was for consideration of supplemental information so that there could be a final recommendation from the hearing committee, and it was voted that the hearing committee would reconvene to consider this information. I don't understand how we could skip over the final recommendation of the committee. My appreciation would be that we would vote on whether to accept or deny the final recommendation of the committee, as opposed to go back to the original recommendation, and that vote for or against it would stand as the anticipated vote, which was the reason why the committee went back to the reason why this board told the committee to go back and to continue the investigation. So I don't understand why we're voting on whether the first recommendation would be accepted or not.
Well, yeah, I guess my understanding, right, having been at that last board meeting, was that as we sit here before us, we have two conflicting committee findings and recommendations.
Yes, but so the board specifically said, and this is provided for in the statute, that the board could choose to ask the committee to reconvene to consider or basically to do an additional investigation. And I think it's quoted here in this final recommendation. And so that's what the committee did. And so it literally said that the matter be investigated further. So I don't know why it would matter whether it conflicts or not. I think the point is that you're going to either support the recommendation or you're going to deny the recommendation. And that in itself is going to have whatever effect it is you're trying to intend with the very first, by voting on the first one, is my point.
So. Yes, Judge Thaxton.
First of all, that recommendation is not on this agenda. That recommendation was dealt with at that board meeting when we sent it back to the committee, number one. Number two, if you want to just simplify this, and I'm stunned that you know from your prepared remarks what Mr. Walters was going to say, but I think the issue here is, are we going to accept, reject, or modify the current recommendation of the hearing committee? Those are the three things the statute provides for. So I would offer a substitute motion that we accept it. And I think that by law, we're going to have to modify it because something's happened since then, and that is these people have lost their jobs since that committee met. So I don't know why we're going around the block to get to, if you want to convert that to a motion to reject, let's vote on it. Let's tee it up and vote on it.
Yeah, well, so I guess I'll start by, just so that the record's clear, the agenda does not state that the report and recommendation of the hearing committee that was returned on June 18th versus the one that was returned on April 7th.
It's because we already dealt with the other one. We sent it back.
And that this was a continuation from, this is a continuation hearing, correct?
Right.
Yeah, from the June 16th.
From the June 16th, right? I feel like we're splitting hairs here, I guess, right?
Well, if
Go ahead, Ms. Boutte, yes.
if I may, I think simply we just vote on based on the law. I mean, we already decided that the committee was to go back and consider additional information. That's what happened, and to then come back and render a recommendation, and that's where we're at. You can agree, amend, modify, or deny the recommendation. It's the same impact, but I don't think that we're moving in the right order with the current motion that's before us.
Yeah, so I don't know. I see it as we're splitting hairs here, right? Whether as the motion stands currently, the motion has been made and there's been a second to adopt the recommendation of the April 7th, which basically is adopting the final viewpoint that the decision of Mr. Starnes was maintained. I hear the position of other board members that, in essence, your position is that we should be voting on whether or not the position of Mr. Starnes should not be maintained, right? I think we're going to get to that final answer in a vote either way. Obviously, if this vote is shot down, then there would be another motion.
My position is that the only recommendation that should be before this board at this point in time, since the June 16th meeting, is the last hearing committee recommendation. And either that's the only one that should be before us in order to vote, for a vote, because we've already, the board, and granted, it wasn't made up of most of the people that are here today. It's neither here nor there. The previous board in the June 16th meeting decided that there would be a second recommendation for consideration. And that's what's before us today.
If I may just point out, and then I'll be quiet.
Yes, sir.
The last paragraph of the recommendation, the committee says they find that the committee recommendation on May 20 is reversed and replaced. I think this is the recommendation we need to be voting up or down on. And we are here to get this completed, to give these people closure one way or the other. I've never advocated one way or the other with any board member personally or in a meeting which way to vote. I think we need to get rid of this, and I would offer a substitute motion that this particular recommendation be accepted. I believe the statute calls it affirmed. So that would call for a vote up or down.
Discussion over here? This is Judge DeMahie.
If necessary, I'll second his motion.
Well, I don't think we're there yet. I'm just open for discussion. Anything else over here? So I guess this is the conundrum that I'm in, right? Because this amended motion would be is contrary to, we haven't gotten the vote yet.
It's a substitute motion, and I do have to have a second for it to get up. So
Right.
That's where Judge Devine.
No, I understand that.
We would vote on the substitute first, I believe.
Well, so
Approval of the substitute would make it unnecessary to vote on the original.
Correct.
approval of the substitute motion would make it unnecessary to vote on the original motion that was passed by Mr. Harbinson. Is that correct? I'm sorry, Mr. Dwyer?
I think what's being said is that by voting on the most recent recommendation.
By voting on the most recent recommendation of Mr. Harbinson?
No.
I'm sorry.
The substitute motion, as I understand it, is to vote on the June 20th recommendation of the committee.
Okay. I'm going to call a recess just so I can take a look at it. Let me just pull up Robert's rules and yes. So maybe we'll do a 15-minute recess just because I want to make sure we get this issue correct. If we could just break for 15 minutes.
Clarify a little bit with Robert's rules.
Well, it doesn't matter. See, because I don't think that's proper. I'm going to move that we do the opposite of whatever the stands. Yeah, it doesn't matter.
And amendment, that's the equivalent of substitute motion.
If the June 18th fails,
Former Justice Alexander.
to say, stop next time.
It says, what is that? Still got some price tag on it. They brought the new lawyers, still got a price tag on it.
Yeah, no, that's fine, that's fine.
That's what we were asking. And you still got section 5 at the end of it. It explicitly says they can remove from later. I'm just telling you. I'm just saying I was there. I'm not.
That makes sense, Steve? Get to
We don't need more.
We just found out. Don't know anything about the other man. Except Stop.
All right, if we could come back to order after taking a break, discussing with the board and reviewing the Roberts Rules of Order, discussing with other board members. Before we begin, if we could just make sure we do have a quorum. I'd like to acknowledge that all members are back, and we do have a quorum. So for clarity's sakes, currently, Mr. Harbison has made a motion in summary to adopt the April 17th hearing recommendation. I'm sorry, the April 7th, 2025 hearing recommendations and findings. That has been seconded by Judge Devereaux. There was a motion to substitute by Judge Thaxton to adopt the hearing committee findings and recommendations of the June 18th hearing committee. That has been seconded by Judge DeMaio. Is that correct? After reviewing the rules of order, we believe that it is prudent that we would first vote on the substitute motion. If that substitute motion is affirmed, then that would be all, right? If that substitute motion is rejected, then we would then defer to the motion of Mr. Harbison to adopt the April 7th findings and recommendations. Let me get this straight. So with that, let me just get back to it. Let's now conduct a roll call vote for the substitute motion by Judge Thaxton to adopt the June 18th hearing findings and recommendations. And Ms. Booty, I will begin with you.
Affirm.
That is one for affirm. Judge Keedy.
Affirm.
Judge Thaxton.
Affirm.
Mr. Harbison.
Nay.
So no. Mr. Landreneau. No. Judge Devereaux.
No.
Mr. Dwyer.
No.
Judge DeMaio.
Affirm.
That brings it to a 4-4. As the chair, I maintain my position of the last committee report that I was at, where I will vote no. So that has now been denied. I believe it is prudent at this point that we move to the original motion by Mr. Harbison, which was on the floor and was already been seconded. Discussion has been had, and this is a motion to adopt the findings of the April 7th, 2025 hearing, in whereby the findings and recommendation of that board was that the decision of Mr. Starnes should be maintained. I will begin the vote with Ms. Booty.
Denied.
Judge Keedy.
No.
Judge Thaxton.
No. Denied.
Mr. Harbison.
Yes.
Mr. Landreneau.
Yes.
Judge Devereaux.
Yes.
Mr. Dwyer.
Yes.
Judge DeMaio.
No.
And I maintain my position as a vote of yes for that. So that motion is passed. Same time. That concludes the business for the agenda item number 4. That brings us, at this time, we'll move to agenda item number 5, which is the adjournment, unless there's anything else that I've missed. Hearing none, I will entertain a motion for adjournment.
I move that the meeting be adjourned.
Motion by Ms. Booty to adjourn, second by Mr. Dwyer. No opposition. This meeting is now adjourned. Thank you all, and I believe we'll just have to reschedule for whatever our next meeting is.
Oh, if you want to do a date, I don't know if we can do that.
Do we want to put that on the record now, or? We're adjourned. We'll get together and we'll post through the public meeting rights. Thank you. That meeting's adjourned.